This podcast is about MJB Enterprises, which is one of the most influential cases in tendering law. In this case, the respondent, Defense Construction, invited for tenders for construction of a pump house and installation of a water distribution system. The call for tenders included a detailed set of directions and instructions, and it also included a privilege clause which stated, the lowest or any tender shall not necessarily be accepted. The call for tenders included information on 3 different types of backfill that could be used to lay the pipe. The costs varied depending upon the materials used. The original tender documents permitted the tenderer to set out the costs for each type of the 3 types of material. The tender documents were amended, however, and deleted references to different types of backfill. So at the end, the tenderer was required to submit one price regardless of the type of backfill used. There were 2 bids in issue. The lowest bid was by Sorocan, but it included a condition not contemplated by the invitation. Sorocan inserted a handwritten note indicating that its bid was based on type 3 backfill, but if type 2 backfill was used, $60 should be added per meter. The owner considered this handwritten note to be a mere clarification and accepted the tender. The second lowest bid was that of the appellant, which wasn't chosen. The appellant had assumed that the choice of which type of backfill to use was at the risk of the person submitting the bid. In the prior proceedings, the appellant brought an action for breach of contract, claiming that Sorocan's bid should have been disqualified and that its tender should have been accepted as the lowest valid bid. This failed at the Alberta Court of Queen's Bench and in the Court of Appeal. So the issue in MJB Enterprises was whether the inclusion of a privilege clause in the tender documents allows the owner to disregard the lowest bid in favor of any other tender, including a non-compliant one. So again, remember that privilege clause reserves the right of the owner to accept or reject the lowest or any tender. A sub-issue coming out of this is, did contract A arise? And if so, what are its terms? So we have to determine the sub-issue first in order to determine whether the privilege clause allowed the respondent to do what it did. The position of the parties was, MJB argued that Defense Construction was obligated to accept the lowest compliant tender. Since Sorocan's bid was invalid because of the handwritten note, which made it non-compliant, the contract should have been awarded to the appellant. Defense Construction argued that the privilege clause gave it the discretion to award the contract to anyone, including a non-compliant bid, or not to award the contract at all. The court found on the issues. First, did contract A arise? Whether contract A arises depends on whether the parties intended to initiate contractual relations by the submission of a bid in response to the invitation to tender. The court found that this was, in fact, the intention of the parties. The court looked back to Ron Engineering and based its decision on the contract A, contract B analysis. Now, it didn't necessarily agree with Justice Estes' characterization of contract A as a unilateral contract, which was stated in Ron Engineering. But the issue was sidestepped here because the court didn't specifically need to consider whether contract A was unilateral or bilateral. We will discuss this later after we finish with MJB. So, what are the terms of contract A? Well, essentially, how was the appellant able to raise the argument that the respondent was obligated to accept the lowest valid or compliant tender? MJB argued for an implied term. What is the difference between an express term and an implied term? An express term will be found in the contract document itself. You will look in the contract and you will read the term, whereas an implied term can be read in by courts. The general principles for finding implied terms are, first, usage or custom, as in the industry. Second, legal incidence of a particular kind of contract. Third, based on the presumed intentions of the parties where the implied term is necessary to give business efficacy to a contract, or as otherwise meeting the officious bystander test as a term which the parties would say, if questioned, that they had obviously assumed. So that's how you find implied terms. Here the Supreme Court made the initial finding that there was an implied term according to the presumed intention of the parties. Note here that the court focused on the presumed intention of the parties, not of the intention of reasonable parties in the circumstances. Here we're not relying on objective intentions, but on the subjective intentions of the parties. So how does the court get over the evidentiary problems that lead courts to normally consider the reasonable person? Well, here, when you're looking at implied terms, the implication of a term must have a certain degree of obviousness to it. If there's evidence of contrary intention on the part of either party, then an implied term may not be found on that basis. So to find an implied term, you have to look at the document and think, well, clearly this was intended to be included here or to apply here. That's why you don't necessarily need a reasonable person analysis. So what was the implied term? Well, the court reviewed the express terms of the tender documents, the evidence and the testimony of the witnesses at trial, and stated that it was, quote, reasonable to find an implied obligation on the owner to accept only a compliant tender. The court considered several factors to come to its decision. First of all, the respondent did not invite negotiations over terms of either Contract A or Contract B. Second, the instructions set out information to be added. Third, any request to amend or any request to amend tender documents should be received 14 days before the tender close time. 4, only one form permitted to be used, and it did not permit any modifications of plans and specs in the tender document. And 5, the tenderer was not expected to add any other items and was expected to submit a valid bid. In light of all this, it was reasonable to infer that the respondent would only consider valid tenders. The court cited policy reasons for this implied obligation. First, the rationale for tendering process is to replace negotiation with competition. Second, that competition entails certain risks for the parties submitting the bids. These parties must extend effort and incur expense in preparing their tender in accordance with these specifications. They must submit bid security, which is a significant amount of money to raise. So in all, what this involves is a lot of time and money spent by the parties that are preparing their tenders. And given all of these policy rationales, the court found that there is an implied obligation for the owner to only accept compliant tenders. Quote, it appears obvious to me that exposing oneself to such risks makes little sense if the respondent is allowed in effect to circumscribe this process and accept a non-compliant bid. I therefore find it reasonable on the basis of the presumed intentions of the parties to find that only a compliant bid would be accepted. Which means that the owner cannot reject tender documents on some undisclosed criteria. It's for the same policy reasons above. It preserves the integrity of the tendering system. In Martel Building and Canada, which was another Supreme Court case in 2000, the court found an implied duty on the part of the issuer, otherwise known as the owner, to treat all bidders fairly and equally. So a bidder who feels it's been treated unfairly or prejudiced through the processing of the bids and in the evaluation of its tender may bring an action for damages for breach of the duty of fair and equal treatment. This is another implied duty in Contract A. So having found an implied term that only compliant bids would be accepted, does inclusion of the privilege clause allow the respondent to disregard the lowest bid in favor of any other bid, including a non-compliant one? So basically, does the privilege clause override this implied term? You can have implied terms in documents, but if the document specifically says something, so it has an express term and the express term is contrary to that implied term, then the express term will override the implied term. Here, what does the clause say? It says the lowest or any tender shall not necessarily be accepted. So the respondent argued that the privilege clause gave it the discretion to award the contract to anyone, as in lowest bid, highest bid, compliant bid, or non-compliant bid. So the court had to look at what the privilege clause meant. And it said the privilege clause means the owner is A, not obligated to award the bid contract to anyone, so the owner can just cancel the project without incurring liability, and 2, not obligated to award the bid to the lowest tenderer. But where the owner does award contract B, the owner is obligated to award it to a compliant tender. A privilege clause does not allow the owner to award contract B to a non-compliant bidder. The privilege clause must be read in harmony with the rest of the tender documents. To do otherwise undermines the rest of the agreement. So in conclusion, the respondent was not under an obligation to award the contract to the appellant, who was the lowest compliant bid. But that doesn't mean that contract A was not breached. What was the breach of contract A here? Well, contract A is an offer of a unilateral contract which is accepted by parties who submit bids. Contract A governs the bidding process. There is an obligation in contract A to accept a compliant bid, and here the respondent breached its contract A with the appellant by awarding the bid to Suracan because Suracan submitted a non-compliant bid. The evidence supported the conclusion that if the lowest tender had been disqualified, the contract would probably have been awarded to the second lowest tenderer, which accordingly was entitled to damages. In Ron Engineering, Justice Esty characterized contract A as a unilateral contract. Now recall from last day, a unilateral contract is where there's an act exchanged for a promise. The offer is accepted through the performance of the offeree. Remember that from Carlo. It's unilateral because only the offeror's obligations remain. Recall that a call for tenders is an offer of a unilateral contract. Submission of the tender is the acceptance of the unilateral contract. Now that's according to Ron Engineering. Is this really a unilateral contract? Well, there are still 2 obligations outstanding for both parties. First, the owner is obligated to consider the submitted bids fairly, conduct fair competition, adhere to disclosure requirements expected. The owner is obligated to return the deposits within a certain number of days of the opening of the bids to the bidders who are not selected. The owner has a qualified obligation to accept the lowest bid, and the tender is obligated to perform contract B if selected. The court in MJB declined to characterize contract A as a unilateral contract, and it sidestepped the issue by stating that Justice Esty was referring quite specifically to the terms and conditions of the tender documents in that case. So in MJB, Justice Iacobucci did not come right out and say that the characterization is wrong, but he did put the characterization in doubt. Now, it is argued that contract A is bilateral, since it consists of promises that are made by both parties to the arrangement. But the mode of acceptance is the act of submitting a bid, as opposed to the usual verbal or written notification that the offer has been accepted. So if we were to construe the call as a bilateral contract, then the act of submitting a tender would not be construed as performance of the contract, but rather as the mode of acceptance to the bilateral contract. The issue has not been revisited since MJB Enterprises, but since the time of Ron Engineering, it has generally been acknowledged that contract A is bilateral in nature.